News First, Newsline with Faraz Shaukat Ali on TV1.
And very good evening to you and a warm welcome to Newsline. My guest this evening is Mr. Geoffrey Alagaratnam, President's Counsel and the former President of the Bar Association of Sri Lanka. Very good evening to you, Mr. Alagaratnam, and welcome to Newsline.
Good evening for us. Thanks for having me.
Thank you very much. Thank you for joining us, Mr. Alagaratnam. We're delighted to have you on our program. And actually, thank you to all the professionals and all our guests who've turned up here, who take their time out to come and speak to us and to the public at large, to put us right on various pressing matters. And one of the pressing matters right now, Mr. Alagaratnam, is this anti-terror bill. Could you tell me what are the concerns that the legal fraternity has in terms of the proposed anti-terror bill?
Fundamentally, for us, as I see it, apart from the provisions of this bill, we know that Sri Lanka is a democracy, and the democracy means the people. And the laws were made to protect society, to protect the people. And if you look at it, the main complaint, I think the Bar Association has expressed its view very clearly, is that none of the stakeholders have been consulted. We've been talking for years about abolishing the Prevention of Terrorism Act, a draconian law which has been used mainly against political opponents and others, and we have been talking of repealing it and a reform. Now, there was a previous bill that was brought that was withdrawn. They promised consultations, they promised to consider all the opinions of stakeholders, but now this, like the other bill, also the online security bill, is just being put forward without any consultation with any stakeholders or the views of others. The main concern here is that, is the law made for man, or is the man made for the law? That is the concern I have here. And for whom are these laws? Is it to genuinely protect society, the country and people, or is it for some other purpose? That's the principal objection we have to this. The anti-terrorism law, or the bill, one of the main concerns is the definition of terrorism. Again, it's overbroad, it's vague. Almost anything can be considered terrorist activity. For example, my criticism of the bill and saying the government has not taken proper steps to consult the relevant stakeholders can also be interpreted as an attack on the state or whatever it is, and you and I can be considered terrorists for discussing these things. That is the plain. Of course, you can never have an absolute definition of terrorism. And also, you know that, all over the world, there is the need for some sort of law to prevent terrorism, even if it's not prevalent to such a great degree at the moment. But when you have a vague definition, you put a lot of people in peril, and we know that the past experience shows that even the PTA was largely used against freedom of expression, people who spoke out, who criticized the government, political opponents, and even people who wrote poems, and people who wore tattoos which they thought were religious symbols, which are found to be the wheel of a ship. So all these type of abuses, many abuses took place, and I don't see that going away when you find the definition of terrorism in this bill. It's overbroad. And if you see, even the period of detention, a person can be kept for 2 months without judicial supervision, without the magisterial intervention, and can be extended further. I think it's far in excess of the citizen's right to liberty, freedom. So that, and also you have in the anti-terrorism bill, for example, you have curfew orders where there are broad powers given for the president to impose curfew orders, whereas under the public security ordinance you can impose curfew even without an emergency. So why do you need these type of broad powers under this anti-terrorism act? Then there are places like, he can designate places as prohibited places, and you can be arrested for being there. So what is the prohibited place? He may even designate this very newsroom as a prohibited place. What is the criterion? What is the definition? Or the Supreme Court?
So what you're saying, Mr. Alagaratnam, is that this is very broad.
Very broad.
Very broad.
And several provisions are covered by other laws which are sufficient for the purpose, too broad. And then even if you look at a thing like prejudicial to national security, what is national security? You look at the determination, the Supreme Court determination on the Right to Information Act, the Attorney General successfully argued that economics and economic development is part of national security. So if you criticize, for example, the DDR, the debt restructuring or any other economic measures taken by the government, you will be imperiling national security. So you could be a terrorist. And proscription orders against various groups. So there are a lot of, apart from the broad definition of terrorism which can catch up almost any activity, there are other sweeping powers as to curfews, prohibited places, proscription orders, which fundamentally offend the rights of the citizens of the country as to freedom of expression, freedom of movement, freedom to practice your trade or journalism, whatever it is. That's my basic take on that. I do not intend to give you a thesis on the Anti-Terrorism Act.
Well, so it appears to me that at the end of the day, when you really look at it, this appears to be the work of government who are concerned about the level of the opposing argument or the alternative, alternative to their position. The people can't express their thoughts. And do you see this as a means of stifling public dissent, an alternative opinion?
Yes, definitely. It is seen as stifling, because where you do something, where you compel the government to do something or compel the government not to do something, all those acts of terrorism. So if you are criticizing some measure of the government, you can be a terrorist. So legitimate criticism, freedom of expression, freedom of thought, all that is in danger with these broad definitions and broad powers.
But there will be some amongst us who will say to you and to me and to everybody else who listen that, look, Sri Lanka has had a severe near civil war for over 30 years. Thousands and thousands of our people died. So one side of the same people were fighting against each other. And so they'll say to you, almost logically, they'll say, look, you say the PTA is no good. It's internationally condemned. You've been trying for years and years to get rid of it. And then now you're saying this anti-terror bill is no good. So what is it? Do we not need any terror laws at all, or is Sri Lanka so safe that we don't need it?
I would not say that we do not need anti-terrorism laws. My major complaint is that, first of all, the terrorism laws are meant for the security of the state. You do need laws in the event to deal with terrorism, but you don't need laws. You have to balance the rights of the citizens on the question of freedom of expression, thought, assembly, association, where they can have gatherings, protests, street protests or anything. You can't have an overbroad definition of terrorism which can stifle legitimate, because after all, in the constitution of Sri Lanka there are the fundamental rights, so you cannot violate them. So that I am not saying that anti-terrorism law is not required. It is, but there has to be a balancing of the conflicting interests, the rights of the freedoms, the fundamental rights of the people. And as has been shown, the past experience under the old laws, the broad definitions have led to just oppressions of minorities, political opponents or personal opponents just for a person having a different personal view, they have been arrested under the Terrorism Act. So the balance has to be struck. That balance is not struck here, and it's overbroad, which can lead to abuse, as we have seen, and gives too much power to the executive, and also takes away judicial supervision and curtails the powers of the judiciary, because after all, the judiciary is the last bastion of the rights of the people, their fundamental rights. It is the final arbiter, and that is under the Constitution. Judicial power is given to the courts, not to Parliament and to the executive, except for matters of privilege. So you have by this law curtailed the powers of the judiciary and given too broad powers to the executive to curtail legitimate fundamental rights of the people. That's how I look at it.
And Mr. Alagaratnam, now do you see a problem brewing? Because we're supposed to have the independence of the different arms of government. So do we have a situation, or do you see something brewing along the lines where Parliament is going to be at odds with the Supreme Court?
Well, that has been very well brought out in recent discussions and expressions, because you saw that even in the recent past, the President himself and the Speaker of Parliament stating that the judiciary has no role to play on decisions of Parliament. Like if you say debt restructuring, and when you put a cabinet approval, whereas that was contrary to the established practice, because it is only an act of Parliament once passed that cannot be challenged. A bill can be challenged within a certain period. A cabinet decision can be challenged. But you had persons no less than the President and the Speaker saying we are not going to listen to the judiciary. The judiciary has no role to play, and they cannot look into things that are done by Parliament or resolutions of Parliament, which is contrary to the legal position, even the established practice in the past, where gazettes and regulations have been challenged. Even emergency regulations have been challenged. And after all, the judiciary is there. If you talk of checks and balances and the balancing of powers, what we fail to realize is that the legislature, the executive, and the judiciary are three organs of government. They are equal partners.
But they can't impinge on each other's territory.
They cannot impinge. That means they can't carry out the roles that the other is doing. But they are there to have checks and balances on each other where there is an abuse by either power, right? And the judiciary is the last hope of the people. We are a democracy. The people and the judiciary is there as the final arbiter between citizen and citizen, between state and citizen. So when you start making inroads into that power, democracy is at stake.
At grave peril, would you say?
Absolutely grave peril, because now you find even attacks on judges, mentioning like recently.
Mr. Alagaratnam, talking about the independence of the different arms of government and where they're supposed to be providing the checks and balances, but they can't impinge on each other's territory and so on, and we understand that. But what we don't understand, and the public seem to be gasping here, is this story about this judge who has sort of resigned, is cited saying threats to his life or whatever, and apparently he has left the country. Should this sort of thing be happening? What is the system that needs to look into this?
Definitely it should not be happening, because if a judge, now there was an attack on this particular judge by a member of Parliament, who also referred to his community or race or whatever it is, and referred to him. So it looked like there was a reference in a very derogatory manner to the judge, who really was conducting an investigation. So whatever the merits or the demerits of the judge's order, one cannot make aspersions on the judge. If the judge has misconducted himself, there are avenues for his disciplinary action against him or for removal of a judge. But when you start attacking judges personally, and when they are carrying out their functions, you weaken the judiciary, you put them in peril. And this judge is supposed to have left. He has alleged that various threats have been made against his life. The ordinary arm of the law should handle this, whether it's the IGP or anybody, and should deal with the persons who have overstepped their limits. So that is assuming that the investigative process is independent, efficient.
Yeah.
Because his security was withdrawn, that was, I think, that was fairly confirmed. He was abused in Parliament. He has made other allegations of threats. Those have to be investigated, because one cannot have this type of situation, because this is the culmination of several acts of intimidation of the judiciary.
As a legal man, that's very deeply worrying to you.
Yes, because how can a judge be independent if he is under threat, under undue pressures, if he is criticized and attacked and ridiculed? How can a judge function freely? No doubt, if there is an errant judge, he has to be dealt with. And the public, as well as the legal profession, should be bold enough to criticize an errant or corrupt judge. But legitimate criticism is welcome. But one cannot have pressures and threats and trying to say that judges should be transferred here, or this judge should be is corrupt, or this judge is personally biased. If that is so, there's a mechanism for his removal or disciplinary measures.
But Mr. Alagaratnam, what can be done? I mean, all these sort of abuses and departures from due process and acceptable procedure and laid down procedure and process is all being violated. What can we do about this? What can be done?
I think what everybody has been crying out for. I basically feel that we have come to the end of the road on various matters where we have to say enough is enough, and we have to set in place institutions and processes that cannot be tampered with by the politicians, whether it's the judiciary, whether it's the police, the public service, the foreign service, because those have become the playing grounds of the politicians, which has to cease. And there has to, like, if you look at ministries, secretaries, the independence of those people, their competence is something that has been unduly devalued, interfered with by the political culture that's prevalent, for which partly I think the citizens are also to blame, because it is we who elect the people to Parliament, and we get what we asked for. So I mean, there has to be a change of political culture, thinking of the people, because it's time we stop thinking in terms of race, religion, caste and family roots. We have got to think in terms of what's good for the country, objectively, what's good for generations to come, not merely our comforts, our benefits, because sometimes we think that benefits from politicians come from their pockets. It's not. It's from the taxpayers' money, the money of the country. But our people, election after election, keep voting in rotation people who have failed to deliver.
I hear what you say, and obviously this is something that we come across as journalists as well all the time, that people will say, oh well, the people deserve what they vote for. But when you and I turn up to vote, the menu card is pretty limited. We've got to choose from one of these lot, and as you say, enough is enough. Many of these people in Parliament, I dare say, shouldn't be in Parliament.
That is why the citizens have to wake up. We have to call for intra-party democracy. We have to, for example, insist on things like, okay, what is the women representation? Do we have 25% of women in a voters list? Do we have at least, I'm not emphasizing qualifications excessively, but at least do we have 50% of professional in a voters list? Because recently somebody said that in Parliament you don't have even 90 people who have qualified, who have passed their O-levels, right? So you have, I'm not saying that qualifications are the A-all and B-all for a good politician, But you had to have a fair mix of these people. You may not have a highly qualified guy, but who's a respected elder in the remote areas, who's good in whether it's agriculture or fisheries. So there are people of integrity. Unless you level the playing field, unless the people insist that you don't put on your party list, because parties tend to put sure winners, hook or by crook, who will come to parliament. So unless you're able to say these people have a checkered past, why are you keeping these people? We are not going to vote for this list if you have people who have been convicted, who have been, say, dubious in their conduct of parliamentary activity or their personal life. Unless the people stand up, we are going nowhere. So it's basically a change of political culture. More, not so much the change of the parliamentarians. We are to blame.
So the people must wake up. I often say that people must get out of their do-nothing seat and get in the jump seat. Because when a jump seat, you can get up pretty quickly and get into action. Is that what you mean?
Because democracy is for the people, not for the parliament or the politicians.
Well, that's the end of our program for this evening. Thank you very much to our guest today, Mr. Geoffrey Alagaratnam, President's Counsel and the former President of the Bar Association of Sri Lanka. Thank you very much indeed. And that's the way it was. Here's me saying, have a great evening as much as you can, and God bless you all.